Hi again. So, welcome to the second class of Internation, which is on written memorials. So, this class is intended to be a very general guide, and that's because, you know, first, I think that memorial writing is a very personal thing in that everyone has a different approach. Personally, I do better when I just go straight into writing. Some people would suggest you to do, actually, most people would suggest you to make an outline first so that your arguments are more structured. I mean, you should go with whatever you're comfortable with, and I don't think that I'm in a position to tell you what's best for you. But second of all, most importantly, you only have a few days before the memorial submission, so I don't think it would be wise to kind of confuse you guys too much. So I hope that this class will be helpful. Oh, I'm Regine, by the way. Okay. So on to first, why memorials are important. Most people think that memorials aren't that important just because, whether you win in the rounds are determined by your oral scores. But that's actually not true. First, memorials do contribute to your round points, which could determine whether you advance to the next rounds or not. Round points are basically the value of your victories or losses in terms of the scores from the highest, mid, and lowest scoring judge. So if you got like an 88, an 85, and an 87, and then your opponent got an 89, an 86, and an 84, then they will compare the scores that you have with your opponents, like the total, like your speaker score in the team. They will compare that with your opponents. If you win, if you get the highest score in that particular round compared to your opponents, then you'll get extra points. If you lose, you'll get less. And it doesn't only apply to the oral rounds. They also take into account your memorial scores. So they will compare the memorial scores from the highest, the mid, and the low judge. So yeah, it's very important for you guys to pay attention to your written memorials for this reason. Round points are not the first things that will determine whether you advance, but they are the determining factor if your victory points and your raw points, which is your overall speaker score, is the same as another team. So it could be your make or break, basically. Second, they provide a good basis for your oral arguments. I think that it's very redundant for a team to write a memorial that is completely different from their oral pleadings. And that's why you should be very accurate in your research from the beginning. And it's just such a waste of time for you guys to have to do twice the amount of research in the same amount of time as your opponents. And it takes away a lot from what you could potentially have explored within that topic if you gotten it right from the beginning. And finally, they make sure that you get an award of some sort if you screw up in the oral rounds, which happens all the time. I know several very good teams which just did not perform well in a certain round or just had a judge not like their arguments. At least your memorials kind of give you something, Okay, so on to the basics. Your memorials must contain the following parts in the following order. So the first thing that you should put in your memorials is a cover page. We didn't actually give you a specific format to follow, and the committee will not penalize you on a format that's slightly different from what is standard in mooting. But you do have to keep in mind the fact that this is an actual moot. In terms of you competing with other teams, you do have to be professional and appear professional and respectful to the other team. So we would not suggest you to stray too far away from, what is the standard format for memorial covers. And furthermore, it's also important for the teams to recall that this is a proceeding before the International Court of Justice. It would just appear much more respectful and professional for you guys to use a cover that's the same as memorial submitted to the International Court. Second is a table of contents. So this is basically something that, a lot of teams write. For some reason, a lot of teams type their table of contents manually. I would not suggest you guys to do that. I would suggest you guys to automate it because there's I think like an option in Word or other similar document applications that would allow you to automate your table of contents. And I think that there are two advantages to this. First, that it takes up less of your time. When you're making a table of contents and you suddenly change something, you're going to take up time to have to reformat everything again, type all the dots and everything that connects the title of the page to the number of the page. And second, it just would be much neater for you guys to not do it by hand, because the computer, would make it a very readable and very neat format. So yeah, that's basically the advantages to having an automated table of contents. If it's not possible for you, then do try to make it as neat as possible. Third is your index of authorities, which is basically where you cite the authorities that you use within within your arguments. Basically, you regroup your footnotes into certain different categories in accordance with their nature. So be it treaties, case law, books or journals, or other things. And the reason why index of authorities are important is because, again, they give a good impression to the judges who are reading the memorials, and they also help the judges locate where you're using a given authority and how you're using it, basically. Okay, fourth is the statement of jurisdiction. So just a bit of a spoiler for this year's case, there is no question of jurisdiction. Both parties have agreed that the ICJ should decide the matter. However, the rule stands that the court has jurisdiction in proprio motu to examine its own jurisdiction, competence, basically. So you do have to make a statement by your state declaring that the ICJ has jurisdiction based on what basis under the ICJ statute. I'm not going to spoil that part for you. Okay, so fifth is the questions presented, which is basically where you convert the heading of your claim into a question-like sentence. And what I mean by that is, for example, in this year's Philip C. Jessup problem, the third question was the third claim was that the respondent had violated international human rights law in the fields of culture and religion by hunting a yak. So the way that you would convert that into the questions presented would be to say whether respondent has violated its international human rights obligations on the issues of culture and religion through hunting the yak. That's basically how you do it. Sixth is the statement of facts. So the statement of facts are in this particular mood. Is it in this mood? It's like each heading text. Okay, so onto the issue of what you'll be assessed on. There are three things that we will score, as will most moots. That's first, the extent and use of your research. Second, the clarity and organization of your memorials. And finally, the style, grammar, and citation of sources. So the first issue, which is the extent and use of research, we're trying to score how well you use your authorities and how many authorities you actually use. So the reason why this matters is because you're making a legal argument, so of course you should have something to back you up. While policy arguments are certainly, important and do have their places in a moot, your argument should be primarily legal in nature, and so your authority should reflect that as well. But of course, if you had a lot of authorities and none of them actually are of any value, then, you would not get a good score either. So you should strike a fair balance between the amount and the relevance of the authorities that you have. And second is the clarity and organization. And there are three things that you should pay attention to here. First is how you use your headings. So headings are important in that they tell the reader, who will be the memorial judges, what to expect from that paragraph. If you had a heading that was extremely vague or that was completely disjunctive from the actual content of that paragraph, then you would not have used your heading well. I mean, for example, if you had a paragraph where you argue that a certain vessel was engaging in innocent passage, which was basically the case in Jessup 2 years ago, you wouldn't do well to make a heading that says vessel X was not breaching international law, or country A is not breaching international law, or innocent passage occurred. Like that's like the last one would be the best among the three, the least of what's it called? So onto the basics. The memorials for Internation are much simpler than other moots. Basically, we only require you to put 3 things in, and that's first, the cover page, second, table of contents, and third, your pleadings. Easy peasy. So as for your cover page, first of all, we do not have a set format. I don't think we're not going to penalize you for making your memorial cover in a different format than what's standard for other moots. But you do have to keep in mind that first impressions matter. Your memorial does have to look professional, and so you can't put anything too ridiculous on the cover. And I just think it would look much more professional if you guys followed the format of memorial covers by states that actually submit claims to the International Court of Justice. And that would just be a very good first impression for your memorial judges. Second is your table of contents. So your table of contents I would suggest you guys to make your table of contents automated. You could just select a certain format for your headings. There's an option for that in Word, I think, and in other types of Word documents. So if you could just turn them into heading 1 and their subclaims as heading 2, you could just automate the entire process and make things much easier for you. And your table of contents, which would be much neater than if you typed it by hand. But of course, if it's not possible, then you could manually type it. But I would not suggest you guys to do that. If you do, please make it as neat as possible so the judges don't have any troubles reading it. So third is your pleadings. So this is basically the most important part of your memorials. Your pleadings should be neat in the sense that you do not intermix different claims. You make a clear division between claims 1, 2, 3, and 4. They should be readable and just make them structured. That would be my suggestion to you guys. Make them structured so that it's easy to follow. So I'm just talking generally here. I'll go a bit more in depth into the actual contents of those pleadings after this. So basically, you will be assessed on 3 things. First is your extent and use of research. Second is your clarity and organization. And third is your style, grammar, and citation of sources. So the extent and use of research refers to how many and what kind of authorities you used. So if you used just a few authorities that are not that strong, then you would have not done a very good job in terms of research. Therefore your argument will probably not be strong. It will not give a good impression to the judges. It doesn't show off your knowledge of the law. So you should, try to find as many authorities as possible. But of course, only the relevant ones. Again, the kind of authorities that you use do matter. So if you just cited some random source, like we mentioned in the previous class, then you'll get a minus on that issue. Second is your clarity and organization. So I basically give my kids 3 things to pay attention to in terms of clarity and organization. So first is how you use your headings. If you made a heading that does not convey what you're trying to say well, I mean, if it's completely it's a complete disjunction from the content of the paragraph following that heading, or if it doesn't actually tell you what the paragraph is about, then that would be just a bad heading, and you should write your heading in a way that would convey your message, basically. So for example, if you had a paragraph where you're trying to argue the law on, let's see, for example, innocent passage, So you're going on and on in this paragraph about, what the legal basis for innocent passage is, how it has been used by the court, how it applies to this case. Like, your heading should reflect that. It shouldn't. So, for example, if you're trying to argue that a vessel is performing innocent passage in the territorial sea, then your heading should say vessel so-and-so was engaging in innocent passage in the territorial sea of so-and-so, right? So you shouldn't just say like innocent passage occurred, or like vessel X was not guilty of breaching international. Like, that's too general. You should make your heading convey the content of your actual paragraphs. Second, are your paragraphs well structured and easy to follow? If they're, it's quite a tricky thing, even for me, to structure pleadings. I mean, in terms of, written memorials, just because, you've done so much research, and I do get this temptation of you guys doing so much research and wanting to show off everything that you know because you think everything's important. It's, you should, pick and choose which things you actually put in your memorials, and you should make the argument that you actually use easy to follow. So, use a format that's, people generally do say that IRAC, which is issue, rule, application, and conclusion, is a good format. I don't think it's applicable in all cases. I've seen plenty of memorials in the past that do not follow this format. But if you are confused, that's a pretty standard format to follow. But you don't have to follow that format as long as you could make it well structured. And the way that you make things well structured is, if you can't actually reflect on it well on your own, then you should. So, onto the point of assessment. We'll basically be scoring 3 things. First, the extent and use of research. Second, clarity and organization. And third, your style, grammar, and citation of sources. So the first, which is your research, basically, we will be judging how well you've done your research and how extensive it has been. So, and we'll be basing this on 2 things, which is how many authorities you use and what kind. So the reason why you should, try to find as many authorities as you can that are relevant on the issue is because it's, if you're making a legal argument, you're acting as a lawyer. So, while policy arguments certainly do have their places in moots, but, your argument should be primarily legal, and that legal argument will be contingent on the authorities that you use. But of course, you should use authorities that are relevant. It would not serve you well to have authorities that do not have much value and are not relevant. So you should keep that in mind. Second is your clarity and organization. And there are 3 things that you should pay attention to here. That's first, how you use your headings. So the reason why headings are important is because they tell you, they tell the reader what to expect when reading that paragraph. And judges will generally skim your memorials to find out the flow of your argument. So if you do not write your headings well, then that will reflect badly on you. So your heading should be relevant to the content of paragraph that precedes it. If you use heading that is too vague or is completely disjunctive to the contents of that paragraph, then it would not serve you well at all. For example, if you had an argument about a vessel engaging in innocent passage, so you're going on and on about, the legal basis for innocent passage, the way that the court has used it, and the content of innocent passage, and how it applies to this case. You cannot make a heading that simply says vessel X was not in breach of international law, or country X complied with international law. It doesn't tell you what the paragraph says. It would leave the reader confused. So you should make it specific. Like, for example, vessel X was engaging in innocent passage in the territorial sea of whatever, right? So that's a good rule of thumb for your headings is that they must be relevant. Second is are your paragraphs well structured and easy to follow? I think that structuring is quite a tricky thing. I mean, I still struggle with it even now, and I do rewrite my memorials very, very often. But, it's a very important part of how you present your arguments. If it's not well structured, then no matter how good your argument is, the reader's never going to understand it. And they're never going to be able to appreciate the full nuances and the importance, basically, of your arguments. So a good rule of thumb here is to follow the IRAC format, which is issue, rule, application, conclusion. So first, you say what the contentious issue is. Second, you state the applicable rule and your basis. Third, you apply it to your case. And fourth, and finally, you conclude. But this is not applicable to all circumstances. I mean, it's a good rule for new mooters, but personally, I do not like following this format when it doesn't suit the tone of whatever it is that I'm trying to convey. I think that, again, memorial writing is something very personal. You could have two people writing in completely different ways that are equally understandable to someone reading the memorial. So, just if you're confused, go back to IRAC. It's good. It's a good guide. But if you feel like your argument would be better conveyed otherwise, then do follow your heart, basically. But make sure that, in terms of clarity, consult other people. You consult other people and ask them how they feel when they're reading your memorials. Something that may sound good to you may not actually sound good to others, and you should, always have a third-party opinion on this issue. Okay. Third and finally is, the third and final question for this particular point is, are your arguments placed logically? If you have a claim that's bolder and would give you more advantages, and a claim that's stronger but a bit more of a concession than the other, then you should know where to place those arguments. It wouldn't make sense to place the concession argument first and then say, well, in any case, we have this bolder argument. It doesn't actually make logical sense. You should know how, it's I think that, placing an argument logically, it is something that you should do by, reconsidering the strengths and weaknesses of each argument, and, which argument is the fallback to the other. And also, if you have, for example, several different elements and they're analyzed in a certain order by the judgment of a court or other tribunals, then you should probably follow that format, just because, the court analyzes things for a reason. So, it would be logical to follow that particular format. And the third and final point is your style, grammar, and citation of sources. So style and grammar, of course, concern whether your the way that you write your arguments is actually likable. I mean, if you just keep droning on and on with a boring format, then no one's, as good as your memorial arguments are, no one's really gonna be interested in reading them. I think that reading memorials making memorials to an extent is kind of like writing prose. Because, it's not prose per se, but it does have, the artistic side of prose, in that, you have to make it interesting. You have to use linguistic nuances and tricks to make it engaging and to make it interesting, just to keep them from being bored, just because this is probably going to be a long memorial. So that's basically the issue of style. Grammar, please check your grammar, because, I personally, to me, I do not mind it when people speak or write in improper grammar. I do understand that English is a second language to a lot of people, including myself. Even I make some grammatical mistakes to an extent. But, when you're presenting a memorial, you're not going to have a chance to clarify to the judges what you mean. So if your grammar is confusing to the extent that your memorial is not comprehensible, then, it's just such a shame, because you will score very low on this particular issue and possibly others, just because the judges will not be able to understand what you're saying. And finally, citation of sources is how you use format and basically put citations within your memorials. Citations are important because they help both the judges and your opponents, in all fairness, to check your authorities and how it has been used. And so the way that you format it should follow the appropriate format, which in this case is the Oscola International Law Citation of 2006. You can find it on Google. I'm not going to go too in-depth on that issue, just because I think it would be better for you guys to read it by yourselves. Okay, so we actually derived from the Jessup, which is the most established international law moot in the world, a checklist on how a memorial is graded. So I think this would also be useful for you guys to get an insight into how judges think when they're actually scoring memorials. So first, when you're dealing with a table of contents, two things matter. First, do the headings and subheadings in the table of contents lay out a readily understandable, clear structure of the arguments on each of the issues. If you cannot understand what a team is saying just from their headings, then you know that team has either chosen to structure their pleadings poorly, or they are unable to convey their ideas well. So again, headings matter, guys. Second, is each heading and subheading forceful and affirmative? It would not do you well to make a heading that's very, soft, I guess, and vague in nature. I mean, just, if you're trying to accuse the other state of an internationally wrongful act, you should say so. You should say what the basis of your claim is. I mean, just make it clear what you're trying to do in this case through your headings, basically. And as for your pleadings, including your conclusion and your prayers for relief, there are a lot of things. So first is the organization of the arguments under each section clear and logical? Again, when you're arguing something within a given section, it should follow what that section is trying to say. Try not to stray too much from what try not to stray at all, actually, from what the topic is of that paragraph. And again, format it in a logical way. Like, just consider how your argument fits in the puzzle of the other arguments. Ask other people to review it for you if you're confused. Just, make it very clear, very logical. Second, the alternative arguments contain an independent basis for deciding the issue. So it's, of course, in a moot, you're always going to have alternative arguments, especially in your written memorials, which is where you lay out all of the potential things that you're going to say. Making a one-layered argument is certainly a bold move, but it would not be good for you in most cases, just because it's very good for a team to always have a fallback issue. Okay, so I'm going to advance this argument. Even if it fails, this court can consider this issue. And even if that failed, then there is still this last fallback, which is so strong that, I need to win on this particular issue. So that's going to be your stance before the court is, whatever you're going to throw at me, I'm going to win. Right? So that's why it's important for you to have alternative arguments. And it's important that they contain an independent basis for deciding the issue. So for example, if you have argument A and argument B being the fallback to argument A, you cannot write argument B with the assumption that argument A is accepted. They're alternative arguments. B is what you resort to when A fails, right? So that's why it's important for you to have independent basis for each of these arguments. Third, do the pleadings focus primarily on the main arguments critical to the case? So if, for example, if you had an argument, if you had a claim that was trying to set out that there is no international obligation to perform nuclear disarmament, you should go into that issue only and not stray into other issues such as, even if there was an obligation, then I have complied with that obligation. That's not what your claim wants. And as important as it is for you to have alternative arguments, make sure that alternative is actually still what your country wants. Like, don't make it, stray too far away from what your country wants, basically, because that will also reflect badly on how you understand the issues that are presented before you. Fourth, does it contain legally correct arguments that nevertheless are not relevant? Right, see, so this is the thing that I was just telling you guys about earlier. So, you have arguments that are legally correct, but your client, which is a state, doesn't actually want you to make that argument under the heading of their claim. Like, do not make that argument. That'll just, decrease your score. Fifth point, for each issue, is there a clear statement of the rules relied upon? So, when you're trying to make a legal argument, again, you should try to make it as clear as possible what rule you're trying to rely on. So, like, if you just made a very general argument that just goes into, like, morals and ethics, I mean, you would write a good, like, philosophy paper, but not a good written memorial. So you should make a clear statement of what rule you're trying to rely on, because that will also help the judges assess whether your argument is actually correct, right? Sixth, is there an appropriate amount of authority with appropriate explanations in support of the existence of the rules relied upon, including examples of actual state practice, judicial and arbitral decisions, opinions of leading publicists, etc. So, in order for you to support your rule, for example, if you're trying to argue a customary rule, then of course you should know the prerequisites to what a customary rule is. The prerequisites to what can constitute a customary rule, and you should cite authorities that would support your contention that customary rule exists. So you shouldn't just go and say, well, it is customary. What's your legal basis, right? Again, you're making a legal argument. Seventh, is the cited authority or of sufficient weight within the confines of Article 38 of the statute to support the advocated conclusion? So, if you were to make an argument on the basis of a secondary source that is not supported by any, that goes against a primary source, for example, I'm pretty sure you all know what Article 38 of the ICJ statute says, so I'm just gonna, go into it. So if you had like a highly qualified publicist that was saying something that was completely contrary to a well-established principle of law, then, it's not, that secondary source would not truly be secondary source in the sense that it cannot help to interpret what the primary source of law is. Just be careful with those things, make sure that they are of sufficient weight. I mean, the court will, of course, regard authoritative figures and as well as, its previous decisions on the issue, for example, far more than some random publicist from some random country who go against the court's judgment, right? Okay, so eighth, does it adequately apply the facts to the rule relied upon or just argue by assertion? Like, you cannot just say, well, rule this and this is like this. My legal basis is this. And then suddenly say, it applies to this case, right? You cannot just argue by assertion. You have to actually apply the facts to the rule that you're relying upon. You have to make it clear what your flow of logic is so the judges can follow accordingly. Ninth, does it use policy arguments to reinforce the arguments based upon legal authority? Again, policy arguments are important in that they do provide a clarification as for why a certain legal rule should apply. You cannot be purely legalistic just because, sometimes a certain rule of law would only apply in certain cases but not others. Just having a policy argument there just helps to clarify why you could apply that rule to that particular instance. 10th, does it openly confront and deal with weaknesses on the law and on the facts? So, like, if you had a weak point and it's glaringly obvious you shouldn't just omit that from your written memorials. Because just because the judges will think that you do not have a way of dealing with a difficult issue that's posed before you, so you should definitely try to just address them openly. So let's just say, for example, indeed, my country's actions are, not very correct on this particular issue, but you cannot blame my country for it. My country is not internationally wrong. It is not internationally responsible because it is not an internationally wrongful act, right? So that's what you should do. Like, you should deal with the weaknesses head on, basically. That's what judges like. 11th, does each citation contain adequate information to locate the authority? Again, if you have a citation, like, there's a part where so you don't only need the title, you also need, for example, the case report, the name of the journal, the publication. So that is what will help people find whatever source it is that you're citing. So you should provide sufficient information for people to locate your authority. 12th, are the arguments clear and easily understandable? Again, just, if you make them too convoluted, like, it's good to think in a complex way in moots. I personally do appreciate people who take the extra mile and take into consideration, the limitations of their arguments and the complexities of it. But you should present your quote unquote convoluted arguments in a way that's clear and easily understandable, which is tricky and will involve a lot of rewriting. But, it's the only way in which you could get people to actually read your memorials, right? 13th, this is long. Overall, are these arguments persuasive on the facts, law, and policy? Again, like, it's not enough for you guys to just write a certain legal basis. You actually have to be convincing in the sense that, you provide a strong basis and then you apply it in the correct way. So that's what's going to make your arguments persuasive. And generally, so just going into the general assessments of a memorial, there are 3 main questions. First, is the memorial well written, well edited, and professional in appearance? Again, this matters as a general impression, and the judges will score you in accordance with how you present your memorials and how you format it. Second, does the memorial demonstrate extensive research and a sound understanding of the applicable law? Again, going back into, so this is basically just an amalgamation of like all of the things that we discussed on the issues of pleadings. Sorry, I discussed. You guys did not. Yeah. But you guys can ask me questions if you want, by the way, for pleadings. I mean, you could just send it to an email. But anyway, so, your memorial should overall demonstrate good research, and you should demonstrate that you understand the law that's applicable and how it actually applies. Okay. And finally, overall, is the memorial persuasive? So, just write your memorial like you believe in what you're saying. I know that sometimes you will deal with difficult arguments and you don't actually trust in what you're actually presenting to the court. But, you should try to make your argument as persuasive as possible, be it by legal or policy approaches. And just write your memorial like you actually, believe in your argument and you trust your own judgment on the issue, right? So, just try as best as you can to be convincing, address the weak points, emphasize your strong points, and if you're confused, you could always resort to other Moot's memorials or the example that we just sent you, which was the best memorial last year, to determine what you should do and, to just get a general guidance on what you should do. Okay, so that concludes our class. Again, if you have any questions on the pleadings, which will be between 4th and 5th May, I think. Yeah, 4th and 5th May, just shoot me an email. Just shoot us an email at internationilsa@gmail.com. internationilsa@gmail.com with any things that you might want us to address. But that's it for this particular class. I hope you guys learned something from it and I hope it was useful. So I will see you guys in the next class.